guys, welcome back to Legal Banter. This is part 2 of the previous video, and here we continue looking at more judgments that were delivered by the Supreme Court in the year 2020. This video will be extremely useful for CLAT aspirants, existing law students as well as IAS aspirants for their current affairs preparation. The next judgment could be considered as a landmark judgment. In the case of Prithviraj Chauhan versus Union of India, the Supreme Court upheld the constitutional validity of the Scheduled Caste and Scheduled Tribes for Prevention of Atrocities Amendment Act of 2018 that had ruled out any provision for anticipatory bail for a person who was accused under the said act. The next case is a big case for women empowerment. In the case of Union of India versus Lieutenant Commander Annie Nagaraja, the court held that the Navy was directed to grant permanent commission to service women short service commission officers, and this had to be done at par with their male counterparts. The court's basis for this decision was that such a distinction was violative of such women officers' rights under Article 14. However, they did subject to the exception of combat roles not being assigned. The next case is State of Madhya Pradesh versus Amit Shrivas. In this case, the court held that compassionate appointment which is done in lieu of a deceased previous employee will not be treated as a matter of right, but will be subject to the rules and regulation of the aforesaid department. The next case was yet another landmark case. It was Gujarat Mazdoor Sabha versus State of Gujarat. This was the case where the court sought to quash the Gujarat government order whereby it had allowed exemption to factory owners from paying overtime wages to its worker during the COVID-19 lockdown. The court ruled that COVID-19 did not present as a public emergency which could have allowed it to seek exemption under Section 5 of the Factories Act. The next case is Ram Babu Singh Thakur versus Sunil Arora and others. This is a landmark case to ensure more transparency in public offices. The court in this case held that it was mandated for political parties hereafter to publish the details of any pending criminal cases or prosecutions pertaining to their candidates. The court directed political parties to upload all such details about their candidates on their official websites as well as in newspapers and on social media within 48 hours of the selection of the candidate or within 2 weeks of the nomination, whichever is earlier. Such information should include the criminal antecedents of the candidate, the nature of the crime, whether the charges have been framed, and the stage at which the trial is. The next case is Rakeshkumar agarwala versus National Law School of India University, Bengaluru and others. In this case, the court quashed the National Law Aptitude Exam, also known as the NLAT, which is conducted by National Law School of India University, Bengaluru, for admitting students to its law courses. The court thereby held that students from now on will be admitted to the said institutions through the commonly conducted Common Law Admission Test, also known as CLAT. The next case is Centre for Public Interest Litigation versus Union of India. In this case, the court refused to order the government for transferring the PM CARES Fund to the National Disaster Relief Fund. The court, while doing so, also held that there is no statutory prohibition preventing the Government of India from utilizing the funds available under NDRF for providing assistance and help in the fight against COVID-19. The court also held that there was also no statutory prohibition on making any contribution by any person or institution in the NDRF as per the Disaster Management Act of 2005. The next case is yet another landmark case for victims of domestic violence. In the case of Satish Chandra Ahuja versus Neha Ahuja, the court held that the term used under Section 2 Clause S of the Domestic Violence Act, which is shared residence or household, does not apply or mean only a household of the joint family of which the husband is a member or in which the husband of the aggrieved person has a share. Instead, the court held that this would now mean that women will have such a right in any household belonging to even a relative of the husband with whom the woman has lived in a domestic relationship. By doing so, the court overruled its previous decision in the case of S.R. Batra versus Taruna Batra. The next case is yet another landmark case. The case name is Vinita Sharma versus Rakesh Sharma and others. In this case, the court held that daughters become equal co-partners at birth even if they were born prior to the 2005 amendment that was made to the Hindu Succession Act. This act had came into force for the daughters, allowing them to get a share in the property of the father. The next case is S. Vanita versus Deputy Commissioner, Bengaluru Urban District. The court in this case held that the maintenance and welfare of parents under the Senior Citizens Act had no overriding effect over the right of residence, or rather shared residence, of a woman under the Domestic Violence Act within the meaning that is so provided. The next case is in recognizance for extension of limitation. This was a suo motu cognizance taken by the Supreme Court, whereby it allowed summons and other notices to be allowed to served through email, fax and instant messaging apps like WhatsApp. The court also in re guidelines for court functioning through video conferencing during COVID-19 pandemic allowed the issuance of directions on implementing exhaustive video conferencing all throughout in the courts of the country. The next case is in re Prashant Bhushan and another. In this case, Advocate Prashant Bhushan was held liable for contempt of court pertaining to his tweets about the Supreme Court and the present CJI SA Bobde. As a result of that, the court punished him by ordering him to pay a fine of ₹1. The next case is in re Problems and Miseries of Migrant Labourers. This case pertained to the suo motu cognizance of the Supreme Court pertaining to the migrant crisis that was effectuated due to COVID-19 lockdown. The Solicitor General was directed by the court to appraise on the steps taken by the government to address and resolve the migrant crisis that had happened. On a later date, the court also made it clear that as per its previous order, migrant workers stranded and affected because of the pandemic were mandatorily required to be transported to their respective hometowns within 15 days after the order being made. The next case is Manohar Lal Sharma versus Union of India. This was an important case because herein a constitutional bench which was hearing petitions pertaining to Article 370, whereby the special status to J&K was abrogated, rejected the request to refer these petitions to a larger bench. The court held that there was no oversight or conflict as there was stated. It primarily gave two reasons for its decision. Firstly, it observed that the circumstances in which these cases were decided were different, and two, the issues involved in the cases were completely different. The two cases that the court was referring to were the cases of Sampath Prakash and the case of Premnath Kaul. The next case is Indore Development Authority versus Manohar Lal. In this case, the court held that whenever there was a delay in paying of the compensation by the government, it did not vitiate or lay down to the proceedings under the Right to Fair Compensation and Transparency in Land Acquisition, Rehabilitation and Resettlement Act of 2013. The court held that the word or that was stated in section 24 clause 2 had to be read as a conjunction of and, which meant that only when possession had not been taken by the government and the compensation has not been paid could it lead to the vitiation or the stay on the acquisition proceedings under the Act. The next case is Chief Information Commissioner versus High Court of Gujarat and another. In this case, the Supreme Court held that petitioners were not allowed to seek pleadings or copy of pleadings under the RTI Act. If they needed so, they had to resort to the procedure under the High Court rules. The next case is Siddharaju versus State of Karnataka. In this case, the Supreme Court held that granting of reservation in promotion for persons with disabilities is not prohibited under Article 16 Clause 1 of the Constitution therein. The next case is Mukesh Kumar versus the State of Uttarakhand. In this case, the court held that reservation in promotions in public positions is not considered as a fundamental right and the respective state cannot be compelled to provide the same as a result of the law. Article 16 Clause 4 allows discretionary power to the state to allow reservation wherever it is needed. But the court held that it is not a mandate on the state and therefore cannot be claimed as a matter of right. That's all for today, guys. I hope you liked the video and learned something new. If you like my content, please like, share, comment and subscribe to my channel Legal Banter. Thank you so much for watching and do hit the notification bell if you want to stay posted on such videos.